Welcome to this mini lecture about designers' intellectual property rights. Design is a great way to learn about intellectual property rights, as one single design product, let's say a light fixture for example, can be protected with all forms of IP protection. So even if you're not a designer, this jump into IP protection gives you a good overview of the topic. My name is Iiris Adenius. I'm a Finnish lawyer and an economist, and for the majority of my career, I have advised designers and design-driven businesses on their rights. Now, those rights are inseparably linked to intellectual property rights. It's safe to say that every designer should understand what intellectual property rights are and how to utilize them in their business. Likewise, any company that takes pride in being design-driven or simply utilizes design or design services in their business can gain significant competitive edge with good understanding of intellectual property rights. Intellectual property rights are significantly underutilized by small and medium-sized enterprises, so this is also a great way to differentiate yourself from your competitors. Let's say, for example, when you're trying to get an investment into your company. In this mini lecture, we will go through the basics of what do intellectual property rights mean from the point of view of a designer and a design-driven company. After this mini lecture, you should have a good understanding of the following things. 1. What do intellectual property and intellectual property rights mean? 2. What do IPRs have to do with design and designers? 3. What are the different types of intellectual property rights? 4. How to utilize IP rights in design business? And 5. How to monitor and enforce intellectual property rights. What are intellectual property rights? Let's start with the very basics. What does intellectual property even mean? So let's say you design and manufacture chairs, and your name is worldwide known for the great quality chairs you design and make. Now, if someone breaks into your storage and steals your chairs, that's property theft. But if someone copies the design of your chairs and starts manufacturing the chairs themselves, that's intellectual property theft. The same goes for a situation where someone starts marketing their chairs with your name on them, even if they would use a different design for the chairs. Tangible property, so the chairs in this example, can be protected physically, like keeping your chairs in a locked storage with camera surveillance and an alarm system, for example. But intangible property is typically easily accessible by anyone, anywhere in the world. So this is why we have intellectual property legislation. IP legislation is our society's way of setting up rules for the use of intellectual property. What do we consider to constitute as intellectual property? What do IP owners have to do to get their IP rights? What do those rights include? And what can the right owners do if someone steals their intellectual property? Different societies regulate things differently, and it's good to realize that intellectual property legislation varies country by country. So please check with a local IP attorney or lawyer for your country-specific legislation. This also means that you need to apply by the local IP legislation in each country or area where you seek protection. The rules we discuss in this mini lecture are based on EU legislation. Intellectual property legislation has always been linked to how easy it is to copy creative and innovative work. The early forms of copyright legislation, for example, were created to grant authors exclusive right for a limited period after the first print press was invented. Before that, such exclusive rights were not granted by legislation, but at the same time, copying a book was done by hand, and so the threshold for copying was naturally quite high. Also, design, creativity, and innovation were inseparable to craftsmanship. But the Industrial Revolution changed this significantly. Copying innovative and creative works and products became easy and cheap. And this is the time that a lot of the early forms of modern IP legislation took form. So the purpose of intellectual property legislation is to protect and incentivize innovation and creativity. Without IP legislation, product and service markets would only be about commercialization power. Sometimes people mistake utilizing intellectual property legislation to mean very restrictive, closed, and controlled method of utilizing intellectual property rights. This is a common way to use intellectual property rights. Only use the innovation yourself and prohibiting others to do so. But it is only one strategy. You can utilize intellectual property rights in a very open and communal way, but still allowing you to prohibit use of the innovation that doesn't match with your values. For example, only allowing ethical and sustainable manufacturing and having the opportunity to prohibit counterfeit products produced with possibly even poisonous materials in dangerous working conditions. So, as a society, we have IP legislation to protect creativity and innovation and to allow creators themselves to make a living from their work. And from the company's point of view, we want to incentivize investments made into innovative and creative works. But as with most legislation and policies, it's a balancing act. So on one hand, we have protection of creativity and innovation, and on the other hand, we have protection of free competition. This is why IP legislation typically grants exclusive rights only for a limited period, and many times exclusive right only applies to commercial and professional use. And some things are categorically left outside of the scope of IP protection, such as ideas, concepts, and recipes, for example. What do intellectual property rights have to do with design and designers? When a product or service is well designed, the design itself has value that can be sold or licensed and should certainly be protected. Design is creative and innovative work, and that means that IP legislation provides means to protect design from being copied or misused. The owner of an EU design, for example, has the exclusive right to use the design and to prevent others from making, offering, putting on the market, importing, exporting, or using a product incorporating the design without the right owner's consent. Design is also a great viewpoint to learn about intellectual property legislation, as design can be protected with a variety of different types of IP protection. Using a light fixture as an example again, the aesthetics of the light fixture can be protected with design and copyright. The brand under which it is sold can be protected with a trademark. The packaging for the light fixture can have its own trademark, and the light fixture can have an inventive or technical feature that can be protected with a patent or utility model. Furthermore, the app that allows you to control your lighting can also be protected with those same measures. Sometimes learning about IP legislation can feel overwhelming to a designer or a small business owner. Next, we are going to go through most important aspects of IP legislation and different forms of protection. The point of this is not to make every designer an IP expert, but to give designers and small and medium-sized enterprises enough information about intellectual property rights to understand their rights early enough to be able to choose what kind of protection serves them best. So the purpose is for you to know enough when you need to reach out to an expert and ask for more specific information about your situation. Different types of intellectual property rights. Design can be protected with different forms of intellectual property rights, and studies show that the strongest protection is created with a combination of different forms of IP rights. Intellectual property rights are typically divided into two categories: copyright and related rights on one hand, and industrial rights on the other. Industrial rights include, for example, design rights, trademarks, patents, and utility models. Let's go over these different forms of intellectual property rights and how do they protect design. In EU legislation, design rights protect the appearance of a product, including its shape, patterns, colors, and ornamentation. This can cover anything from the design of a car to the car handle to a piece of furniture or clothing, or a design of an icon in an app, for example. The new design legislation will extend the protection further to non-physical products. Design rights protect the visual aspects, allowing designers and businesses to secure exclusive rights over the aesthetic elements of their products. To qualify for protection, a design must be new, which is the novelty requirement, meaning that no identical design has been made public before the application date or before it was first disclosed. And 2, have an individual character, meaning it gives a different overall impression from existing designs. This is important to understand. The design does not need to be absolutely market disruptively new. Sometimes designers especially place the threshold of design protection higher than it actually is. Also in EU there is a grace period of 12 months, which means that a design can still be registered within 12 months of it first being published. However, it is absolutely recommended to register before publishing your design. To obtain EU design, the designer or small and medium-sized enterprise must file a design application within EUIPO. The applicant submits a representation of the design, so drawings or photographs, along with a description and a list of products which the design will be applied if necessary. The strength of the design relies heavily on the decisions made during the filing process, and this is why it is important to utilize the expertise of a good design attorney to get the strongest possible protection. Once registered, the design is first published, and then the design right gives the owner exclusive rights to use the design and to prevent others from using it without permission. The design owner can enforce their rights through legal actions against unauthorized use. This protection lasts up to 25 years with renewals every 5 years. Unregistered designs offer more limited protection. While they protect against direct copying, they do not protect against independent creation of a similar design by another party. Utilizing unregistered design can be a good tool to protect designs in industries where products have short market lifespans, or when one has missed the registration period for an EU design. But defending unregistered designs can be costly, especially taking into consideration the relatively short protection period it allows. Trademarks. Trademarks help customers identify where a product or service comes from. In EU legislation, a trademark is a sign or symbol that distinguishes the goods or services of one company from those of another. This can include words, logos, slogans, shapes, or sounds, or colors. The purpose of a trademark is to protect the brand identity of a business by ensuring that the consumers can clearly identify the source of a product or service and preventing confusion in the marketplace. When it comes to design, a trademark can protect the design brand, the name of a product, the designer themselves, and the company selling the design product, for example. In case someone markets their products under a design brand, and that doesn't belong to them, trademark legislation gives you tools to prohibit that kind of use. To obtain protection, a trademark must be registered within the EUIPO. The applicant should provide a clear representation of the trademark and lists of goods or services it will cover, classified under the NIS classification system. This means that the same name or logo, for example, can be used for different products or services as long as those trademarks are registered in different classification categories. Once published, third parties have the opportunity to oppose the registration if they believe the trademark conflicts with their existing rights. If no opposition are filed, or if they are resolved in the favor of the applicant, the trademark is registered and published in the EU Trademark Register. Once registered, the trademark owner has exclusive right across all EU member states. Only the trademark owner can use the registered mark in relation to the goods and services it covers, and the owner can take legal actions against anyone who uses similar or identical signs that could confuse consumers and customers. EU trademark is initially valid for 10 years from the date of filing. The registration can be renewed indefinitely in 10-year periods, provided that the renewal fees are paid and the trademark is genuinely used. Patents and utility models. Patents are a form of industrial rights that provide inventor an exclusive right to their invention, allowing them to prevent others from making, using, selling, or distributing the patented invention without the permission of the right owner. In Europe, a patent can be granted for an invention that meets 3 criteria: novelty, inventive step, and industrial applicability. Utility models, sometimes known as mini patents, are a type of intellectual property protection for innovations that are generally simpler or have a lower threshold of inventiveness than those required for a patent. Not all EU countries recognize utility models as a form of IP protection. One important thing to note with patents and utility models is that the novelty requirement is absolute. This means that in case you publish your invention, it is no longer considered new, and the patent or utility model criteria is no longer met. So there is no grace period for patents and utility models. Utility models generally offer protection from 6 to 10 years, whereas patents can be valid for up to 20 years. Again, patents and utility models give the owner an exclusive right to prevent others from commercially exploiting the invention in the countries where the patent or utility model is valid. Copyright and related rights. So let's now view the other part of intellectual property rights, where industrial rights make up one part and copyright and related rights make up the other part. Copyrights protect original works that express intellectual creativity. Typical examples of copyrightable work being books, movies, graphics, music, paintings, and designs. According to EU legislation, copyright refers to a range of rights granted to authors, performers, producers, and broadcasters, and also designers. And those rights are further divided into economic rights and moral rights. In order for any work to get copyright protection, the work must be original. That means that the work bears the imprint of the author's personality, their sensibility, their non-imposed choices, and their perception of the subject. So copyright protects only the specific expression of the work. The same idea, the same concept can be used by others freely, and others can get their own copyright protection as long as their work is also considered original. One of the great benefits of copyright protection is that in many countries and in EU, copyright is granted automatically, as long as the work is considered original. So no registration is required. Copyright protection period is also long. Copyright can be valid from the time that the work is created until 70 years has passed from the author's death. While gaining copyright can be smooth, proving that you have copyright protection can be time-consuming and expensive. When it comes to protecting design, it's good to keep in mind that copyright very much applies to design the same way as it does to other creative works. However, combining copyright with industrial rights, such as design rights and trademarks, for example, leads to a stronger protection than copyright alone. Copyright gives the right owner an exclusive right to utilize copyrighted work and to prevent others from utilizing their work without permission. How do designers utilize intellectual property rights? There are 3 main ways designers typically utilize intellectual property rights. First, utilizing them in their own business. 2, licensing the design to 1 or more customers. And 3, transferring all rights to a third party. Utilizing intellectual property rights in your own business is especially important if you commercialize your own product or service. This means identifying what to protect, protecting the chosen rights, and enforcing and monitoring the market. Licensing means giving somebody else the permission to use your intellectual property, like a trademark, patent, or a design, in exchange for a payment or royalties. It is like renting your invention or brand while you still remain the owner of it. The licensee, aka the person who gets the license, can use the design under specific terms agreed upon in a license agreement. IP transfer means selling all of your rights to a third party. This typically means not having any rights left to your design, except maybe right to royalties, but this and other terms should be clearly established in the IP transfer agreement. Monitoring and enforcing IP rights. Intellectual property rights typically grant their owners exclusive rights, which means in practice that the right owner has the right to prohibit others from making or commercially utilizing their intellectual property. This means that the right owner must be active in monitoring and enforcing their rights. So first, you need to monitor the markets so that no one else brings products or services to the market that are too close to yours. And second, you need to monitor the IP registries and oppose in case someone is trying to register a right that is too close to yours. If you encounter that someone has already infringed on your intellectual property rights, or you suspect that they might have, it is always recommended to consult an IP lawyer or IP expert on the matter. At this point, you need to establish very clearly what rights you already have, what rights might have been infringed, and what kind of remedy are you looking for from the third party, and how you want to continue on the matter. Remember that there are options for mediation provided, for example, by the EUIPO. Lastly, remember to renew your IP registrations.